Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today, before we start with our today's analysis, a quick gentle reminder. Spardha Lines is starting one of the test series which is very important for all those of you who are preparing for CTI, PDO and KAS examinations. The test will be conducted both on the online as well as on the offline mode, and this current affairs test is scheduled to be conducted from 26th of November and will take place up until 17th of December. This is completely free, and also remember, when we speak about these test series, they are curated by the experts who have seen what kind of questions can come and appear in all these examinations. So this can be very important for you to crack the nut. And remember, these questions have been asked in the past. We will also cover questions which can come up in the near future as well. So it will be a comprehensive test series that will be given by the Spardha Lines team. Let's get started and look into the first MCQ and the first article for the day. Who among the following was considered to be the preceptor of Mirabai? Dadu, Raidas, Ramanand, Surdas. The answer to this is Raidas. Why have we taken this practice question? Because this article on the Hindu makes a reference to Mirabai, which is why we have taken this practice question. When it comes to Mirabai, who was the preceptor of Mirabai? It happens to be Raidas. Raidas is also known as Ravidas. This can be very important from your preliminary examination point of view. So the first question is answered. And now, as part of the assignment, you have to put on the comment section who was the teacher or the spiritual guru of Raidas or Ravidas. Who is the spiritual guru of Ravidas? Please put it on the comment section. Let's look at some of the important facts with respect to Mirabai ji. Mirabai was a 16th century Hindu mystic poet and devotee of Lord Krishna. She is a celebrated Bhakti saint. Mirabai was born into a Rathore Rajput royal family in Kudki, which happens to be in the modern day Pali district of Rajasthan, and some Hindu temples such as the Chittor fort are dedicated to Mirabai's memory. So Mirabai happens to be a devotee of Lord Krishna and she was preceptor of Ravidas or Raidas. These are very important pointers from your preliminary examination point of view. Now let's look into the next practice question. Which among the following is the best description of Defiant project? Drivers and effects of fluctuations in sea ice in the Antarctic, studies on the ozone destruction, an influential resource for legal advisors and policy experts dealing with cyber issues, integrated coastal zone management project. Which among the following is the best description of the Defiant project? The answer to this is drivers and effects of fluctuations in sea ice in the Antarctic. This happens to be a project that is executed by United Kingdom, where you will have number of people and legal researchers who will ultimately say what are the changes that we are witnessing when it comes to the quantity of ice, quality of ice that we have in Antarctica. So the drivers and effects of fluctuations in the sea ice in Antarctica is what is called as the Defiant project. Why have we taken this practice question? Because this article on the Hindu makes a reference to the Defiant project. So we have the Defiant project which happens to be a research which is part of UK based project called as Defiant Drivers and Effects of Fluctuations in Sea, which is set up a ground based radar system to take measurements of the sea ice in the Antarctica. So the amount of sea ice that is present in Antarctica will be studied and they will come out with a research based paper. So what we have is a ground based radars that are placed in Antarctica. Now let's look into the next practice question or the article. Teen who stabbed minor boy 50 times was involved in another murder, said the police. So what are we speaking about? This article here is speaking about a minor. Who is a minor? Any individual who is less than 18 years of age happens to be a minor. So if a person is committed an illegal act and this person happens to be a minor, What are the kinds of punishments that can be given to this individual? This is covered under a law called as Juvenile Justice Act of 2015. So the Juvenile Justice Act basically speaks about two kinds of people. One is a child who is in conflict with law. The other is a child who is seeking for the protection and welfare of the child. Who is a person who is in conflict with law? Let's say, for example, there is an individual, a minor who is less than 18 years of age, has committed an illegal act. If a person who is less than 18 years of age has committed an illegal act and such individuals fall within the bracket of less than 18 years of age, they will be covered under the Juvenile Justice Act. So what is this Juvenile Justice Act? It has two components. One is a child which is in conflict with law. The other is a child who is in need of care and protection. So a person who has violated laws, conducted an illegal activity, happens to be a child who is in conflict with law. Who is a child who is in need of care and protection? Any person who is found without any home or settled place of abode and without any ostensible means of subsistence, who is found working in contravention of the labor laws for the time being in force, or is found begging or living on the street, is a person who is in need of care and protection. So if we look into the Juvenile Justice Act of 2015, it has a preamble. What does the preamble say? It says an act to consolidate and amend law relating to children alleged and found in conflict with law. What is conflict with law? We just discussed. Means a person, a child who is alleged or found to have committed an offence and who has not completed 18 years of age on the date of commission of such offence. So a person who has committed an illegal act is a person who is a child in conflict with law, and children who in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social reintegration, adopting a child-friendly approach in the adjudication and disposal of matters is the best interest of the child, and for their rehabilitation through process provided and the institution and bodies established herein under for the matters connected therewith and incidental thereto. So basically this Act of Juvenile Justice Act looks into these two parameters. So who is a child? Any person who is less than 18 years of age will be a child. When we speak about the Juvenile Justice Act, there are three kinds of punishments or three categories of punishment that we can look at. One is what is called as a serious heinous offence. The second is what is called as a serious offence. Third is what is called as the petty offence. So there are three cases or three offences that we have to look at when it comes to the Juvenile Justice Act. What is this heinous offence? Let's say, for example, a person has committed an offence in the Indian Penal Code where the punishment is greater than 7 years. So if the punishment is greater than 7 years, such will fall under the heinous category. Now what if there is a punishment that is imposed in the IPC where the punishment is between 3 to 7 years? In that case, it will fall under the serious offences. Anything which is less than 3 years will fall under petty offences. So what are the kind of offences that we have? We have heinous offence, serious offence and petty offence. What would happen? Let's say, for example, there is a child who is less than 18 years of age has committed an act which is illegal in nature. Now what would happen if he has committed a petty offence less than 18 years of age? Any individual who is less than 18 years of age has committed a petty offence. What is petty offence? In IPC, if the punishment imposed is less than 3 years, that individual will be covered under the petty offences. So what happens if a person has committed a petty offence, irrespective of what the crime is, if it is less than 3 years of age, this person will not be thrown behind bars. So there will be rehabilitation, education that would be given to them, and they would also be placed in the child-friendly homes as well. So in most of the cases, they will not be punished, they will be given rehabilitation, they will be in the child-friendly home, so on and so forth. Similarly, if an individual who is less than 18 years of age has committed an offence where punishment is between 3 to 7 years, again they will be put to the child-friendly home. There will be advanced level of changes that will be brought in this person. But if it is a heinous offence, which means the IPC, the punishment is greater than 7 years. Let's say, for example, a murder, or let's say, for example, a rape is committed. In that particular case, this person will be sent to the Juvenile Justice Board. So what happens? If a person has committed an heinous offense, so only if a person has committed an heinous offense, this person will be sent to the Juvenile Justice Board, and whether he had the mental capacity to think over that crime, whether he knew the consequences of that particular crime, he knew why he was committing that particular crime, and it has not happened in a fit of rage, but instead it happened to be a cold-blooded murder. All of this will be taught by the Juvenile Justice Board, and ultimately if it is proved that this person has committed a serious offense, and if he happens to be within the age group of 16 to 18 years, in that particular case this individual will be treated as an adult. So when will a person be treated as an adult? If that particular person happens to have committed a serious offense, he knows why he is committing that particular offense, he knows the consequences of that offense, it does not happen in a fit of rage, that is, it does not happen immediately because there was some altercation that was happening, but instead this happened to be a cold-blooded murder. In all these cases, if it is proved that this individual was not acting as a child but had the viewpoint or the perception and a thinking ability to commit that murder, in that case this person will be treated as an adult. So who will be going to this court? It will be these individuals who are less than 18 years of age but above 16 years of age. If they have committed to the heinous offense, they will be sent to the Juvenile Justice Board. So the Juvenile Justice Board also has a structure as well. Notwithstanding anything contained in the Code of the Criminal Procedure, state government shall constitute for every district one or more Juvenile Justice Board for exercising the powers and discharging its functions relating to children in conflict with law. So any individual who is in conflict with law, that is committed an illegal offense, will come before the Juvenile Justice Board. A board shall consist of metropolitan magistrate or a judicial magistrate of the first class, not being the chief metropolitan magistrate, with at least 3 years of experience, and 2 workers selected in such manner as may be prescribed, of whom at least one shall be a woman, forming a bench. So it will be a 3-member committee. One we will have is a metropolitan magistrate or judicial magistrate of the first class. That's the person who will be there as part of the board, and then you will have 2 social workers. One will be a person who will be a woman, and the other will be a social worker who have at least worked in all these domains. So no social worker shall be appointed as a member of the board unless such person has actively involved in health, education, welfare activities pertaining to no children for at least 7 years, or a practicing professional with a degree in child psychology, psychiatry, sociology or law. No person shall be eligible for selection as a member of the board if he has any past record of violation of human rights, has been convicted of an offence involved in moral turpitude, has been removed or dismissed from the service of the central government, has ever indulged in child abuse or employment of child labour, and the state government shall ensure that the induction, training and sensitization is provided to all these individuals. So these 3 people will ultimately form a part of the Juvenile Justice Board. So if there is a child who is less than 18 years of age, has committed an illegal offence, and if he's committed a heinous offence, so such a child will go before the Juvenile Justice Board. The Juvenile Justice Board will ultimately decide whether he has to be treated as an adult or as a child. So if a person is treated as a child, that is, he did not know, he is less than 18 years of age, he did not know the consequences of the crime, it happened immediately within the fit of a rage, so there is impounding, bombarding that takes place, and he bludgeons another individual. So at that particular moment he had not planned, he did not know the consequences of that particular crime, it happened immediately in a fit of rage. So this individual will not be treated as an individual who has committed an offence as an adult. So whatever adult, so if he is committed as a child less than 18 years of age, above 16 years of age, that individual will again be put to the juvenile home as well. But what if he knew the consequences of it? What if he knew the ramifications of it? What if this child knew that if he is committing this particular murder, he would know the consequences of it? In that case, this individual will be treated as an adult, and he will also be thrown behind bars as well. Remember, go back to the year 2012. There were about 5 people who had committed a heinous offence of rape against a girl in a running bus in National Capital Region, Delhi. At this particular moment, there was a lot of hue and cry, and as a result, they introduced this new amendment, or they brought about a new change as well. In fact, when you look into the NCRB data, you have the NCRB data which also points out that number of people who are from the age group of 16 to 18 have been committing these heinous offences. That is due to their lifestyle changes, that is due to the influence of the social media. So they knew the consequences of what they were doing, they knew the ramifications of it, and ultimately the NCRB data clearly points out that many individuals between the age group of 16 to 18 have been committing these heinous offences, and that is why there was a change that was brought in the criminal amendment. And now what we have is the Juvenile Justice Act, which has said that if the individual knew the ramifications of it and he is between the age group of 16 to 18, that person will be thrown behind bars. So that person will be treated as an adult. However, this individual, when he is taken by the police, as soon as a child alleged to be in conflict with law is apprehended by the police, such child shall be placed under the charge of a special juvenile police unit or the designated child welfare police officer, who shall produce the child before the board without any loss of time, but within a period of 24 hours of apprehending the child, excluding the time necessary for the journey from the place where such child was apprehended. So if it is not proved, he will be treated as a child, but if it is proved, the child court will ultimately convict him. But do note, whenever there is conviction of this particular child, this child cannot and never be imposed with a death penalty. Now what if there is an individual who is about 18 years of age, about 21 years of age, has committed a heinous offense? Can this person be thrown behind bars and immediately also be subjected to capital punishment? Yes, this person can also be thrown behind bars, and this particular person can also be convicted of an offense which is like death penalty or life imprisonment. But if it is a child who's committed an offense and he happens to be less than 18 years of age, above 16 years of age, he cannot be convicted for death penalty or for life imprisonment. So the child's court shall ensure that the child who is found to be in conflict with law is sent to a place of safety till he attains the age of 21 years, and thereafter the person shall be transferred to a jail. So after the conviction, for the next 3 years, if he is less than 18 years of age, up until 21 years, he will not be thrown behind bars. Why? That is because he will not be sent to the prisons where the adults are present, because he may be influenced by these adult jailers, he may be influenced by these adult individuals who are present in the jail, and they may actually tend to corrupt this individual in this thought process. So they may corrupt the individual, they may put them into a particular state of mind where they assume and start preferring criminal batches of these people, because these are the individuals who are above 18 years of age and they are thrown behind bars. If these children come under the influence of these adults, they may continue to fantasize the crimes as well. So in order to prevent them, give them the intention that crimes are bad for the country, reformative mode is taken. For the next 3 years up until 21, they will be behind bars. Where? But not in the regular jails, but in the child homes, and after they are 21, they will be ultimately thrown behind bars in the jail, so that they know what is good or bad, provided that the reformative services like educational services, skill development, alternative therapy such as counseling, behavior modification therapy and psychiatric support continues to persist for all these individuals. And do note, such an individual who is thrown behind bars cannot be imposed with death penalty and also with life imprisonment. They should be allowed to come outside the jail, and such dates should also be prescribed by the children's court. So it can be 10 years, 11 years, 12 years, 7 years, whatsoever it is, that should also be defined in the conviction and in the punishment. They cannot be imposed with death penalty or for life imprisonment, and they should be out at any point in time. And remember, whenever death penalty is being imposed or capital punishment is being imposed, we follow a doctrine called as the rarest of the rare doctrine. This rarest of the rare doctrine was also judicial innovation which was interpreted in one of the cases called as the Machi Singh case. So it is the Machi Singh case which gave this interpretation of rarest of the rare doctrine, and only an individual will be imposed with death penalty if there is a rarest occasion where such a heinous offense has been committed. Let's say, for example, there are this entire number of people, for example a minority community, or for example a CST community, or women who have been killed in a brutal and heinous of a ways, that will fall under the rarest of the rare doctrine. So in those cases where it meets the parameters established by Machi Singh in rarest of the rare case doctrine, such individuals can be put under the death penalty or capital punishment. For rest of them, what the Supreme Court has said is provide them the life imprisonment. So what is life imprisonment as shown in the movies? No, it is not about 14 years or anything. When I say life imprisonment, it is for the entire life of the person. As long as that person is alive, he will be thrown behind bars. But then you also have pardon, so on and so forth, that can also be applied as well. But then ultimately remission, all that can be applied. But then if we say life imprisonment, it is for the entire lifetime of that individual, and it is not only for 10 years, 14 years or 20 years, but for the entire lifetime. But the juveniles will not be imposed with life imprisonment and death penalty, is what we have to understand. Why did we discuss about all this? That is because the police officers in this instant case have said that this individual should be treated as an adult because he knew the consequences of the crime that he's committed, and in fact he also knew what could have happened in the past as well. So the Juvenile Justice Act will come into picture in the present situation. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says in the secrecy. What is this article speaking about? The article here is speaking about India and Canada relationship. The India-Canada relationship is not that good right now. Why? That is because Canada made an allegation directly over India that its agency as well as its people have been using some of the secret agencies to assassinate the individuals who happen to be the citizens of Canada. Had it been a statement that was made in private, India would not have minded. India would have also reciprocated back as well and would have taken steps immediately. But what exactly happened? You had the Prime Minister of Canada who immediately happens to speak in the parliament and blames the Indian agencies and Indian individuals without any statement, without any proof or the validation or the evidence, and as a result India and Canada's relationship are not that good, and which is why India had asked Canadian diplomats to withdraw, and at the same time Indian diplomats also moved away from Canada. They were back from Canada to India, and this ultimately created a bleak relationship between India and Canada. So this article currently goes on to say that India's decision has now resumed to start off with the e-visas. So we are starting off with the e-visas as well, but at the same time we also have to watch out carefully because we also have United States of America which has said that Indian agencies may also have been involved in planning for a Khalistani assassination who happens to be another person who has become a major irritant to India. So United States of America has also come out and said that India and its agency may assassinate one of the Khalistani leaders, and as a result there is once again a bleak relationship between India and Canada in this situation as well. So basically this article goes on to say that India and Canada will have to re-establish faith in each other because there will be education of the students who will be moving which will be hit, then there will be trade which will be hit, then there is strategic relationship will be hit, economic relationship will be hit. So in order to address all these issues, what we have to do is regroup as countries so that we can address each other's issue, is what is this article all about. Now let's look into the next article. This article says, should online movie reviews be curtailed? We have discussed about this article couple of weeks back in a daily current affairs discussion, which is about review bombing. What is this review bombing? When we speak about review bombing, what happens? Let's say for example, there is an individual. This individual, what does he do? The minute a movie is released, he immediately starts putting out his perspective in a negative limelight. So basically he would have watched the movie. If it is a critical analysis or a constructive criticism of the movie, it is a fair go. But because this person is paid, there can also be a paid collaboration with other people as well. Without even watching it properly, what does this person do? He starts giving negative impression about this movie. The minute he starts giving negative impression about the movie, because of the fast pace of the social media, this message is spread out immediately and people will stop going to the movie theaters and will stop watching this movie as well. And who will be the major sufferer? It is the producer of the movie, the director of the movie, the actors of the movie who become the ultimate sufferers. In order to ensure that review bombing does not take place within 1 week, what we have is few producers and directors who've gone before the Kerala High Court and they've asked for a gag order, which basically means these people will not be able to watch the movie for about 1 week, or even if they watch the movie, they should not be criticizing the movie for about 1 week, so that these people would be able to recover the money within 1 week. So there is a question that comes up immediately. Is it not a violation of Article 19 of the Indian Constitution, which speaks about free speech and expression? So this article currently goes on to say that no, this is not about violation of free speech and expression. To a limited extent, what we also have is Article 19 of 1 of F, which also makes sure 19 of 2, which also makes sure that there are reasonable restrictions. So if the High Court feels that this can also be a reasonable restriction, if it is not a genuine criticism or constructive criticism, or there is no merit in that particular case, because it happens to be a review bombing, which means it has a negative impinge attached to it, it is also being surfacing because someone is actually paying for it. In that case, there can be restriction that can be imposed on the movie reviews. So what is your take? Should online movie reviews be curtailed? Please put it on the comment section. Now let's look into the next article. This article says, Dalit family denied entry into temple. High Court refuses to quash criminal plea against the accused. So what is this article speaking about? This article primarily says that there were few castes which did not allow people from SC/ST community to enter into a temple. And this is where there are two concepts that we have to look into. One is what is called as historically temple entry movement. We will not be discussing this, but whenever you see a topic in the paper, you also will have to connect it to the static part. So when we speak about the static part, we have the temple entry movement which was taken up in Kerala. So as part of the assignment and as part of the examination, read about this temple entry movement which happened in the state of Kerala. So you have number of people who had also participated in it, and ultimately those people who were not immediately allowed during those times were allowed to enter the temple. In the present situation, there were few people from few specific castes who did not allow the people from a Dalit community to enter into a temple. Because they did not allow these people to enter into a temple, it is a violation of law, and whatever criminal proceedings were initiated against those individuals from certain communities, it continues to be persisting, and in case it is proved that they have committed such a crime, they would also be convicted as well. They had appeared before the High Court and they said that they did not make any appeal in the public forum, which is why this particular section does not apply. But what did the High Court say? The High Court said that since this particular issue occurred outside the premises of a temple, and since outside the temple is also a place where you can also have public gathering, since it is outside the temple, these people have committed an offense and they will not be allowed to be, and such a petition of quashing of the particular crime will not be entertained. So the court said, since the incident took place outside the temple door, it was certainly a public place and contains necessary ingredients of 3 of 1 of S and R of the Act for intentionally insulting, abusing members of the ST community in a place within the public view. So this is another point. And remember, despite we being in the 21st century, despite having all the caste barriers, we continue to be hit by these caste barriers, we still do not follow the normal humanitarian principles, and ultimately some of the people still ask, why do you require reservation, so on and so forth. It is for this very reason. When we are not able to think as humans, when there are social barriers for their empowerment, this reservation at least will provide them a tool and a module so that they are also empowered and have the representation in that particular area. When we are divided by caste, when they do not have the representation in that particular area, this reservation will at least ensure that their representation is felt in that particular premises, which is why as long as there is no annihilation of this entire caste system, or even if the caste system persisting, we do not actually surface this in the outside forum, as long as that does not happen, we will continue to have all these kinds of issues, is what is this article all about. Now let's look into the next article. This article here is speaking about Meaty Cafe. What is this Meaty Cafe? This happens to be one of the initiatives taken by one of the entrepreneurs, where people from the physically disabled community will be provided job opportunities so that they would be ultimately able to make a livelihood means and mechanisms. So this Meaty Cafe is one of the fodder for your UPSC mains answer writing on the social issues front, where you have disability, which is your topic that is present in GS paper 1 social issues. So what are the measures taken for inclusivity of the disabled community? So you can also point out that the private sector, especially entrepreneurs, are coming up with new initiatives so that they become part of the inclusive society, and one such mechanism is the Meaty Cafe, where if you step into this particular cafe, people who would be there are the people who would be from the disabled community. Either they are on the wheelchairs, or they might have a vision problem, or they might have a hearing problem. These people would generally not be providing the work. These people would not be provided the work as well as job opportunities. To provide them the job opportunities, this Meaty Cafe has been initiated by an entrepreneur, and now this Meaty Cafe is also present in the Supreme Court of India, managed entirely by persons with disabilities on the court premises. So this can become a fodder for your UPSC mains answer writing. So this is it for today, and if you're liking these initiatives, please do like, subscribe to our YouTube channel and share it with your fellow aspirants as well. Thank you for watching. All the best.